Colleagues, friends, and dear students. Over the past 2 decades, much of my work has focused on one fundamental question. How can the international community prevent and respond to some of the most conscience shocking crimes perpetrated against populations around the globe? This work has taken me into conversations with diplomats negotiating UN resolutions, ministers shaping policy, UN officials, and civil society organizations documenting atrocities, and victims and survivors who have experienced the devastating consequences of the international community's failure to act. Across all these conversations, my messaging to them has remained constant. Mass atrocities rarely occur in silence. They're preceded by warning signs, patterns of discrimination, escalating violence, the erosion of institutions meant to protect people, and the gradual normalization of impunity. The tragedy is not that these warning signs are invisible or that there is a lack of early warning. The tragedy is that time and time again, the international community lacks the political will to prevent and respond to mass atrocity crimes, of ethnic cleansing, war crimes, crimes against humanity, and even genocide, despite clear and stark evidence. Another central challenge in atrocity prevention is the persistent failure to identify early enough when patterns of violence indicate the risk or reality of atrocity crimes. Too often, policymakers hesitate to call warning signs what they are. Yet, this hesitation is not merely semantics. How a crisis is diagnosed shapes the urgency of the response. Accurate diagnosis is prevention. When the violence is misdiagnosed, action is delayed, policy options narrow, and opportunities to protect civilians are lost. The lesson is clear. Atrocity prevention is not simply about producing early warning. It is about ensuring those warnings translate into timely political action, grounded in an accurate understanding of the violence taking place and informed by the realities communities themselves are experiencing on the ground. And today we do not need to look far to see the consequences of this failure. From Gaza to Sudan to Myanmar, civilians continue to bear the devastating costs of violence, impunity, and geopolitical paralysis. These crises remind us that the challenge of protecting population is not a problem of the past. It is one of the defining moral and political tests of our time. In this keynote, I want to reflect on why the norms that safeguard our shared humanity, norms that have been painstakingly developed over the past 2 centuries, must be defended, and what's at stake if we fail to do so. A central part of this normative structure has been the development of international law, including international humanitarian law, international human rights law, alongside the creation of the multilateral system as we know it in the aftermath of the Second World War in 1945. Over the past 25 years, this architecture has been further strengthened by the emergence of more robust protection frameworks, including the adoption, as Mr. Simonovich talked about, the norms such as the responsibility to protect, designed to safeguard populations from the gravest of crimes. The international legal system, therefore, remains central to how protection is understood and practiced. Ultimately, protection depends on states living up to legal and political commitments they themselves have made. And when these commitments are ignored or selectively applied, it is civilians, ordinary people, who pay the price. Friends, the modern international system was not built simply to regulate relations between states. It was built to restrain violence and protect human dignity. The global architecture that emerged after the Second World War, from the UN Charter to the Universal Declaration of Human Rights to Genocide Convention, and the development of the international criminal justice, including the creation of the International Criminal Court, reflected a recognition that the international community could no longer remain indifferent. Its purpose was clear: to save succeeding generations from the scourge of war and to protect populations from the worst forms of violence. Over time, protection has therefore become an increasingly central principle of global governance. And each of these developments reflect a profound shift in how sovereignty itself is understood, not merely as control, but as a responsibility. This understanding was crystallized in 2005 when over 150 UN member states politically committed to the responsibility to protect. R2P affirms that every state has a primary responsibility to protect its populations from genocide, ethnic cleansing, war crimes, and crimes against humanity. And if a state is unwilling or unable, then the international community has a responsibility to help that state through diplomatic, humanitarian, coercive, as well as non-coercive measures. It marked a profound shift in how sovereignty was understood. No longer could it serve as a shield for the commission of atrocities. Instead, it was reframed as responsibility, a duty to safeguard life, dignity, and rights, and to protect populations from the most shocking crimes. If we look at the arc of the past 2 decades, something striking emerges. The norm has taken root. Atrocities are no longer hidden behind the claims of domestic jurisdiction or dismissed purely as internal matters. We don't hear that anymore. We don't hear any state claiming that, well, you cannot question me because this is an internal matter. That's the conversation of the past. The world now has a vocabulary and a shared expectation that mass atrocities are concern of all humanity. And that, my friends, is no small achievement. But today, the credibility of this protection architecture is facing one of its most serious tests. In the span of just the last few years, we have witnessed the deliberate targeting of civilians at a scale that raises profound concerns about atrocity crimes, including genocides in Gaza and Sudan. Children, women, humanitarian workers, and journalists are being killed at an alarming rate. At the same time, in Ukraine, Myanmar, Ethiopia, attacks on essential civilian infrastructure have become a recurring feature of modern warfare. Electricity grids are struck in the dead of winter, water systems and desalination plants are destroyed, hospitals, schools, and humanitarian convoys are repeatedly targeted. These are not simply collateral consequences of war. In many cases, the destruction of civilian infrastructures appears intended to make life unbearable for civilian populations, depriving people of water, heat, shelter, and the basic conditions necessary for living a life. These crises differ in geography, in actors, and in political context. But taken together, they reveal something larger. They reveal what we describe as a global protection crisis. International humanitarian law is increasingly being invoked, not as a shield for civilians, but as a vocabulary through which their targeting is rationalized. We see mass evacuation orders issued to entire populations with little regard to the most basic question: where are civilians supposed to go? In Gaza and more recently in Lebanon, hundreds and thousands of people have been forced to evacuate by orders issued by Israel. In just 2 weeks, nearly 1 million people were reportedly displaced in Lebanon from around 14% of the territory of the country of Lebanon. The Office of UN High Commissioner for Human Rights has warned that such actions may amount to prohibited forced displacement under international law. Safe corridors are announced, yet in reality, there are often nowhere safe to go. Areas are declared safe zones only for those very places to come under attack. We see densely populated urban areas designated as military objects because a small number of militants may be present within them. We hear repeated claims of use of human shields, often asserted without credible evidence. In many cases, this risks eroding the protection civilians are entitled to. Schools and hospitals, sites that should enjoy the highest level of protection, are struck and attacked, again accompanied by claims that they are being used for military purposes, often without any independent verification. And we see the continued use of so-called double tap strikes, particularly in Ukraine, where first responders rushing to rescue the wounded are themselves targeted. The danger is not only immediate loss of civilian lives. The deeper danger is that the law itself begins to be hollowed out, not openly rejected, but interpreted in ways that allows almost anything to be justified. When the law meant to protect civilians becomes a language through which their suffering is explained away, we should all be deeply concerned. But recognizing this danger should not lead us to abandon international law. Quite the opposite. When the law is manipulated, the answer is not to discard it, but to defend it more vigorously. International humanitarian law, human rights law, and the broader architecture of international justice remains one of the most important tools the international community has to restrain violence and protect populations. Without these norms, the protection of civilians could be left entirely to the discretion of power. The challenge before us, therefore, is not to retreat from international law, but to insist that it's applied consistently, credibly, and without exception. Not because the legal framework itself has collapsed, but because states increasingly apply it selectively. Too often we see governments invoking international law when condemning their adversaries, while remaining silently when their allies violate the same principles. International law cannot function as a menu from which states choose only what is politically convenient. Its legitimacy depends on its universality. Take the recent escalation in Iran. The US-Israeli strike of aggression against Iran was undertaken in violation of international law and the UN Charter, as they exercised use of force without authorization from the UN Security Council or without the demonstrated threat to their security that would trigger the right to self-defense under Article 51 of the UN Charter. Despite the illegality of the US-Israeli strikes during an emergency session in the UN Security Council on 27 February, few members condemned the use of force by Israel and the US in a manner consistent with their condemnation of Iran's subsequent retaliation. Instead, states reinforced a pattern of double standards. While Iran's regional attacks, violation of international law, and repression of its own populations were rightly condemned, US-Israeli action were framed as justified exceptions rather than blatant violation of UN Charter framework that bind all states. It was deeply alarming to see several other states expressing further scrutiny of US-Israel actions is not conducive at the moment, with Germany signaling that it is not the time to lecture our partners and allies. This reflects a broader pattern among member states of framing violations in ways that implicitly or explicitly confers de facto permissiveness for unlawful unilateral actions by states viewed as partners while condemning similar conduct by others. The US continues to face limited consequences for its invasion of Iran, whereas the international condemnation of Russia's invasion in Ukraine in 2022 was rightly met with swift and unified action. In the immediate aftermath of 7th October 2023 attacks, Israel was similarly granted carte blanche to brazenly ignore obligations under international humanitarian law and perpetrated wanton destruction against an already besieged population in Gaza. And the international communities issued only shallow warnings to Israel. The asymmetry is telling. When governments invoke legal principles only when politically convenient, they risk weakening the very framework they claim to defend. When international law is applied inconsistently, it undermines its deterrent effect, signals that rules are negotiable and emboldens perpetrators who calculate accountability depending on politics rather than principle. For populations at risk of atrocity crimes, the erosion translates directly into increased vulnerability. If the rules designed to protect them are not upheld consistently, then protection itself becomes contingent and unreliable. This is why insisting on the universal and consistent application of international law is a core component of effective atrocity prevention. We have seen similar dynamics in other contexts. Take the situation in Venezuela. In January this year, the United States conducted an operation on Venezuelan territory and forcibly transferred Nicolas Maduro to the United States to face criminal charges. Whatever one thinks of the Maduro government, and there is no question that Venezuelan authorities have committed grave and systematic human rights violations, including crimes against humanity, since at least 2014. The manner in which the operation was carried out raised serious questions under international law. The forcible seizure and transfer of a sitting head of state from a territory of another country sits uneasily with the fundamental principles of sovereignty and the UN Charter. Yet much of the international reaction focused less on the legality of the action itself and more on the deeply troubling human rights record of the Maduro government. In other words, the conversation quickly shifted from whether the action itself was lawful to whether the target of the action deserved it. And this is precisely where the danger lies. International law cannot depend on whether we approve of a particular government. The rule of law does not operate on the basis of moral sympathy. It operates on the basis of legal principles. To be clear, this is not to defend the actions of the regimes such as Iran or Venezuela. Both governments have for years, in the case of Iran for decades, engaged in systematic repression and serious violations of human rights against their own population. But acknowledging these crimes does not create a legal justification for unilateral or extraterritorial use of force. If anything, allowing political judgments about regimes to determine whether international law applies risks further weakening of the very frameworks designed to restrain power. Because once legality becomes contingent on what the target is, the rules themselves begin to erode. And when the rules begin to erode, it is civilians and ultimately the global community that pays the price. So in conclusion, what does this all mean for you? As students, scholars, and future civilian, as well as military practitioners. First, it means that recognizing that defense of international law is not only the responsibility of diplomats and governments. It is also the responsibility of citizens, scholars, and students. International law survives not simply because it is written in treaties or embedded in the institutions. It survives because people insist that it matters. Because people question, because people challenge power, because people hold governments accountable when they fall short of the commitments they themselves have made. As academics and students, your role is not simply to analyze the world as it is. It is also to ask how it might be different and better, to question comfortable narratives, to challenge double standards, and to insist that same rules apply to everyone, and to remind governments, including your own, of the legal and political commitments they have made. Sorry. My work as an advocate and practitioner has taught me that change rarely comes from silence. It comes from persistent questioning, from evidence, from moral clarity, and from people who refuse to accept that injustice is inevitable. The defense of international law is not an abstract legal exercise. It is about protecting real people, real lives, and real futures. And ultimately, the question we face is a simple one. Will we allow the rules that protect humanity to erode under the weight of power and convenience, or will we hold the line? Thank you.